Welcome everybody to AIB Radio, County Assemblies, Jean Blaine and Maria Janet on this 11th day of June 2011. Take it away, Jean.
Can you see my screen?
Yes.
Okay, last week we talked about the electronic federal tax payment system. Now, this is the booklet that tells you how to set up an account. There's two types of accounts that you can set up. One is a business account for which you must have a EIN number. The other one is a individual account for which you must have a Social Security number. That's your taxpayer identification number. And it tells you, if you want to go through this, it tells you how to make a payment, and it gives you the number. It says payments must be made or
we're
scheduled.
Not seeing that, Jean. Hold on. We're seeing your webinars on Saturday. So you don't have your screen up there yet.
Okay, let me shrink this down.
While Jean's doing that, I want to remind everybody there was still 7 people that did not get approved because they didn't verify their payments to me. 3 emails went out today all day trying to get these people to answer, and I had to send out 3 emails to everybody that that made a payment but did not register. So you're all sent the links to do this. So I don't know why you cannot get step 1 and step 2 done. Some of you I've had to ask more than once because my computer did not lock in, and I had to go back and search about 1,000 emails to find out where you gave me notice 6 days ago. So if I ask you again, it's simply to verify because I'm not able to get you on a list that I'm approving from. And I appreciate and am very grateful for all your patience in that area. Go ahead, Jean. We still have webinar is on Saturday.
Make sure you got your recording going.
It is going now.
Okay, can you see the screen now?
No, I see your webinar. Let me
How about
see
now?
what this is. Wait a minute, maybe I have to minimize this. No, that, uh-oh.
How about now? Can you see it now?
I took the whole thing off the screen. I don't know what I did. That's your GoToWebinar. I'm not seeing your screen at all, Jean.
Okay, let me hit this thing again.
There's your screen. Okay. Now I see what you're reading. Okay, I think everybody else can see it, and our screenshot guy can see it too.
This tells you how to enroll in the class. Can you see it now?
Yes.
I'm making it bigger so you can read it.
Right.
Okay, here's what it says. It says all federal taxes for both business and individuals can be paid using EFTPS. Payments must be scheduled by 8 p.m. Eastern Time, the day before the due date, to be timely. It sounds like they run theirs just like we do.
Yeah.
For additional information, see frequently asked questions. section of www.eftps, which means Electronic Federal Tax Payment System.gov. They're going to electronics to get rid of all this. And I've been told that a lot of one of my students has been using, and he was told this by an IRS agent, that you have to use the 1040 ES, estimated tax, in order to make your payments. People have been using the 1040B. They must have changed that, because it says in the instructions to use the 1040B. But the IRS agent says that you have to use the 1040 ES. And let's see, I think I have that here somewhere. Now, let's see, 1040 ES. People are sending in the 1040B, which is the incorrect. At least this is what an IRS agent said. For those of you who haven't seen the 1040 ES, here's what it looks like. I'm going to show you the this is the instruction booklet. You should read the instructions before you try to use this. That's the instructions. Or I should say that's the form. The form and the instructions are part of the form you want to use is down at the bottom. Here's what it looks like. Can you see my screen?
Yes.
Okay.
It's like a coupon, isn't it?
Yeah, it's a payment voucher.
You want to go through each of those boxes so everybody understands it?
Yeah, it says, here's what it said. There's two of them, and they're filed quarterly. When you use this, you have to file this in the proper quarter, which the payment voucher designates. I'm going to show you that. Notice it says calendar year due January 17th, 2012. There's two of these vouchers here. If you use the wrong one, they're not going to accept it. Intentionally left blank. Okay, here they are. Here's the. Notice this. Notice what this says. Can you see those?
Well, voucher 3 says calendar year due September something 2011.
Says September the 15th, 2011.
Okay, and voucher number 2 says due June 15th.
June 2011.
So we've already
And voucher
bypassed voucher 1.
voucher 1 says April 18th, 2011.
And we've already
So
passed
since we've passed that, so you're going to have to use
2 or 3, 2 and or 3, whichever time you're going to get it done.
So what they're doing, to show you how effective this is, I just got I did a letter for this lady on her credit card. The credit card company reduced it from 12,000 down to 4,000. And they said that if we don't pay this by, I think it's June the 14th, they're going to file a 1099-E. All right, excuse me, a 1099-C, a debt cancellation. This is what they do. What these corporations are doing, and you need to understand this, they're billing you for their tax.
Okay,
I'm telling you.
Let's go through some of the boxes on, say, payment voucher 2, so people can see how to do it.
Can you see that all right, or do you want me to blow it up?
Just make it a hair bigger. I can almost read it.
How about now?
Okay, your first name and initial.
This is your first name and initial.
That's
so
it.
You put your
last name.
Then you put your first name, like mine, Gene B, and you put Keating here. You put your last name in this box.
Is that capital letters or does it matter?
You know, you use your capital letters. Remember that all capital letter name is a legal estate.
And then the Social Security number has the dashes.
Then you put your Social Security number over here.
Okay.
Which is your taxpayer identification number.
If you don't have a spouse, yep. If you don't have a spouse, you don't put anything in the spouses. If you do, you put your spouses in there.
If you have a spouse, if you don't know what a spouse is, it's your wife.
Or husband. And then
you file, but this is only if you file a joint payment.
Right.
Which means you got to file a joint return. Is there anybody that doesn't understand that? This is how they're accepting payments now.
Okay.
They were using the 1040V, but they've done a switcheroony on us. Because because of all these people have been sending in 1040Vs. You want to use a 1040ES, which is an estimated tax.
Okay, so up in the dollar and cents?
You put the amount of estimated tax. Now, I was told by somebody who's doing this, you leave this blank. You don't put the amount in there. You let them fill it in.
Okay.
Now, this is what they told me.
Now, is this what you attach to your private money order?
Yes.
Okay.
Yes. To your private money order. So, again, you got to follow the directions. You got to file the one for the proper date that has the proper date on it. This is for June 15th, 2011. That's the quarter. These are filed quarterly. Quarterly means every 3 months. Now, this is, you know what's interesting about this is this is what SEC does. They have to file their B5 prospectuses. They have to file those quarterly, every 3 months. So this would be June, July, August. And this is April, May, June.
Okay.
So this would be for the preceding period before June, which would be May, April, May, June, which is 3 months. So it would be June 15th, May 15th, April 15th, and March 15th. So what they're doing is they're going from May to June. They go from April, May, June, which is your 3 months.
Mm-hmm.
But you got to file the correct quarterly return for the quarter in which you're filing. Otherwise, they're not going to accept it.
Now,
So
if you have a CPA that is authorized to do the electronic filings, they can do that for you?
Yeah.
Okay.
So again, this is an estimated tax. This is the form you use. Instead of using the 1040B, you use the ES, 1040 ES.
All right.
Estimated tax.
So then we don't need that other form, the 8206 or whatever you called it last week?
The 8109, they phased that out, but you can do this electronically. This is if you do it by mail. If you're doing the money orders, pay to the order of. Whoever you make it pay to the order, charge the sum said to, and you put whoever you're charging it to, whoever sent you the bill.
Yeah.
Then you put credit the memory of my account. Then you turn it over on the back.
And that's where you
write on the back.
Redeeming lawful money per 412.
Yeah, for redeeming lawful money of the United States. And then it's in Section 411, 12 U.S.C. Section 411.
Right.
It's what you write on there.
Yeah, we went over that a few weeks ago, redeeming lawful money of the Treasury of the United States per Title 12, 411.
This is the reason that these REMICs are not, and I'm finding out, and these courts are picking up on this. They're not transferring the funds, which is the note and the deed of trust, to the REMIC. So the REMIC is in default at closing, and it's unsecured. Well, when it's unsecured, there's a clout on the title because nobody owns the loan. The REMIC is reported to own the loan. They don't, because they never transferred it. So this goes to your title insurance, which is, what that means is that there's no insurable interest. What do they have to do in order to have an insurable interest? Somebody has to have title and ownership of the loan documents.
Which they don't.
Who has title and ownership of the loan documents?
They don't, because they do securitization and they split the deed from the note.
Yeah, you can't do that.
So if
They've
you're going
separated
to court on any kind of an issue with a conditional acceptance, to anything like they're coming in on unlawful detainer, a question would be, upon proof of claim that loan such and such was not was not uninsured without any insurable interest on such and such a date. Not, you know, the day.
If there's a cloud on the title, that means there's no title insurance.
Right.
Because there's no insurable interest. And what that means is I called up Chicago Title and talked to them. And here's what they told me. Chicago Title is the biggest title company in the United States. And they told me that if there's a defect in the title, I said, what would happen if there was a defect in the title? And here's what they told me. They told me that if there's a defect in the title company is liable to both the creditor and to the borrower. So you got what you have is that's what you call errors and omissions. They don't tell you this, but you have an errors and omissions insurance. They don't tell you this when you talk to title companies. I have a practice that goes into this, a title insurance practice. This is the practice that they use. And I have a case. We won't have time to go over it tonight, but we can go over the case. These people won errors and omissions, and the errors and omissions had to pay the insurance. The title company, that's what you call an errors and omissions, which is covered by title insurance. So they have to have this as part of their policy. So they're liable to both on the errors and omissions, they're liable to both the borrower and to the lender. But now the question becomes, if the loan documents weren't transferred at closing, then that means that the loan was in default at closing and that there was no lender. So who are you going to insure if there was no lender?
Right.
I've been trying to tell people this for 15 years, and now it's all coming out. There never was a loan.
Never could be.
That's why, there couldn't be, because they never funded it. The REMIC never funded it. So, because they never funded it, there never was a loan. In other words, the REMIC never had the funds for a loan to take place. So there never was a loan.
So everybody could essentially file suit against the title company on that one point alone.
Yes, you can sue the company, or you can file a claim. Which is what we are doing. We've got a claim that I put together, but I decided that it would be, and I'm not giving this out for the simple reason I don't want this given to people and misused. If you misuse this, you're going to get into trouble. And what we're doing is filing it with the Department of Treasury and the IRS. And I'm putting together a forfeiture complaint. I've got the complaint done. All I need is the names of the the claimants. We are going to be claimants in a forfeiture action.
Well,
and in this,
everybody on our webinar list here would want to be included as a claimant.
okay, here's what we're doing. We filed a claim. And what we're doing is asking for a recoupment and a set-off, which is a reconveyance and release of lien. And we're also filing a claim to the proceeds. So we're asking for two things. On the investment side, we have a possessionary right and a property right in the proceeds.
So to follow in your footsteps shortly here, it shouldn't take long to adjudicate that, is that people would be able to stand on that precedent-setting case to get their remedy.
Yes, we're going to do. What we're doing is we do all the paperwork, and we're charging $3,000 for the paperwork. And here's what it includes. It includes an ag lien, which I've gone over with you, but we've made some additions to the ag lien. It includes an ag lien, a 3949A, an 8300, because these are cash transactions over $10,000. That's what an 8300 form is used. Now what we do is we file and we do a 4490 form, proof of claim. So you got 3 tax forms, plus you have an ag lien. And I got somebody that I'm paying to fill out the tax forms. I do the declaration. I have a declaration. And what we're doing is this is 50 pages long. Actually, it's 54 pages. And what it does is it tells you what the basis and the grounds are for the claim. And we're filing it with the Department of Treasury. And we're actually putting a lien on the Treasury, on the Department of Treasury. And the reason for that, and we don't want people doing this unless they know what they're doing. We've already filed 2 of them. They've been in there for 15 days. And what we're doing, and I'm going to explain to you what we're doing and why we're doing it. We're putting a lien on there, on the Department of Treasury, because they are bailing out these banks using taxpayers' money. Like they bailed out Bank of America. They paid Bank of America $127 billion. Remember, they're borrowing on the credit of the United States, which is the American people. But the United States is, as we know, is a private corporation that's in receivership. Remember, all these people are debtors in possession under a Chapter 11 reorganization, acting as trustees to the bankrupt estate. They're not creditors, they're debtors. So what we're doing is, since we're bailing out all of these people, we're entitled to restitution and reimbursement. So again, I'm asking for restitution and reimbursement because they're using our money to bail these banks out. Yes. And under contribution, which means to pay for, and this is called contribution among joint tortfeasors. It's what it's called. Every state, if you go in there into your state statutes, every state has adopted the Joint Tortfeasors Act. And what contribution is an extreme form of indemnification. Indemnification comes in, there's 4 parts to a indemnification. The first one is express. The second one is implied. The third one is restitution. And the fourth one is statutory. So there you got express indemnification, implied indemnification, statutory indemnification, and restitution indemnification. So those are the 4 aspects of indemnification.
Let's remind our listeners that there is no statute of limitations because it was all perpetrated under fraud. There is no statute of limitations on fraud. So if you have older accounts, older mortgages, older situations, they're all covered under this because there is no statute of limitations.
Let me see if I have a treatise, which I'm going to dig out, that goes into this. I'm not going to look for it now. But what it is, I know the professor. He's a friend of mine.
I'll make it.
That wrote this.
Treatise on what?
It's on contribution.
Contribution. Okay, I'm making a note.
And I'll find it, and I'll send it over to Maria, and she can give it out to people so you can see what's going on. Now, what you're doing is when you indemnify somebody, it's called a suretyship contract. And Rule 14 of the Federal Rules of Civil Procedure allow you to do a third-party complaint under contribution as an in rem proceeding. And I've got a complaint that I did. We did the complaint. I charged the people $5,000 for the complaint. They gave me $3,000 up front. I did the complaint, and I gave them the complaint, and they filed it with the court. But they never served it. And I said, if you give me the other $2,000, I'll have the complaint served. So they never gave me the other $2,000, so we never got the complaint served. So what happened is, I don't know what happened to the case, but I think the case they got rid of the case because they don't want this kind of thing out into the public domain. You can sue them as third-party plaintiffs. I sued the judge. I sued the government under the Suits in Admiralty Act, which is 741 through Section 781 of Title 46. Talks about that. You got the Public Vessels Act in there, and you got the Suits in Admiralty Act. And what you can do is you can sue them under the Suits in Admiralty Act. They've consented to be sued. That's because all of this revenue, and I'm bringing this up because revenue is a part of Admiralty Maritime law. This payment voucher that's on the screen is a part of revenue. So it's a part of this Admiralty Maritime jurisdiction. And what you are doing is you're paying off all these people's debts. You're actually doing a suretyship contract, which is a loan of money. And I have a case. This is a third party. Let me see if I can find it. If I can't find it, what I'll do is give out copies of this complaint.
Okay.
This is a third-party complaint that I did. And this was actually filed in court, in district court. Yeah, here it is.
Okay.
Well, this is what.
We'll put it in an attachment.
Yeah, let me find. This is one that somebody did. They used my complaint, but they didn't do it right. But it shows, it gives you case law in there that shows Well, I'll have to find it. It's
Okay,
it's in here.
I've made a note, so we'll be putting that on attachments.
And what it is, you can be, it's an in-rem proceeding under contribution, and you need to read Rule 14. In fact, I can go in there and show you here. I'll show you the rule. Let me shrink this. For some reason, this you have Firefox?
Yes, I do.
Do you use Firefox?
Yes, I do.
I have problems with it all the time. Like just saying it wouldn't bring this up, but Google Chrome brings it right up. Now this is the rules that some of my students in Hawaii, and I did when I was doing the other classes with Toby, I gave out a copy of my complaint, and this woman it shut the whole case down.
She put it in her case and it shut it all down?
Yeah. See here, see it says third-party practice?
Mm-hmm.
Okay, so see where it says 3?
Yeah, plaintiff claims against a third-party defendant.
Whoever you're suing, they become, you want to remember, in 1966, they took all of the Admiralty Maritime rules, and Alfred Knuth did this. He merged all of your Admiralty Maritime laws with the federal rules of civil procedure. This is one of the reasons when you sue these people, you're not getting anywhere. When you sue them, when you do a regular civil complaint, you've got to do an Admiralty Maritime complaint, and this is the one you should be doing. They shut the whole courtroom down. They sued the judge in rem. And here's what you do. It says, third-party complaint in rem. If it is within the Admiralty or Maritime jurisdiction, a third-party complaint may be in rem. In that event, a reference to this rule to the summons includes the warrant of arrest. Now remember, this is civil.
Mm-hmm.
They go out there and arrest these people. Are you following me?
Yep.
Includes the warrant of arrest, and a reference to the defendant or third-party plaintiff includes, when appropriate, a person who asserts a right under supplementary Rule C6A1 in the proposed arrest, in the property arrest. Now this is an in rem proceeding under supplementary Rule C.
Okay.
And in here, let me find it. It talks about contribution. See, you can do, it says, must assert any defenses against a third-party claim under Rule 12. Well, see, this is all Admiralty.
Okay.
Remember, it says here, it talks in Rule 13 is a counterclaim. Remember, there's two types of counterclaims. There's a permissive and mandatory. I'll go over here and show you.
Is 13G mandatory?
Yeah, it's a mandatory counterclaim. So the reason I'm bringing this up is you have a recoupment. That's what recoupment is. It's a counterclaim. And this is a mandatory counterclaim. And so what we're doing is giving them notice in this declaration as to our counterclaim. These people haven't paid the tax on the capital income. So all this capital income they're holding, allegedly holding in this REMIC, is contraband because they haven't paid the tax on it.
Correct.
So I'm going to do a supplementary rule G, which is a forfeiture. Now, if you go, you can do an XRL forfeiture. You can do a forfeiture on, because it's under supplementary rule C6. Which is an in-rem proceeding. This is what the IRS does. When they do a lien on you or levy, and a lot of you have been levied and liened, that's what they're doing. They're using supplementary rule C.
Okay. So how does this apply to somebody that's in...
Okay, here it is. Supplementary Rule C, Admiralty or Maritime Claim. It says if a plaintiff asserts an Admiralty or Maritime Claim under Rule 9H, and what Rule 9H says, I'm going to show you what it says. I'll pull it up. Come on, Betsy. Not coming up.
Oh, we have a question here. Is it $3,000 per webinar participant or per mortgage?
Per mortgage.
Okay.
If you don't have the whole amount, you can put $1,000 down on it. Or we'll take $500. We're trying to get this done. We want to get enough people so that we can do, we're going to do a forfeiture. And if this talks about,
how long do you think it's going to take to do a quiet title with your process? Should be pretty.
This is not a quiet. This is not a quiet title. This is a forfeiture.
Right.
Okay. Here's what this says. This says scope of impleader. If a plaintiff asserts an Admiralty Maritime claim under Rule 9H, the defendant or a person who asserts a right under Supplementary Rule C6A, that's an in-rem forfeiture, may, as a third-party plaintiff, bring a third-party defendant who may be wholly or partially liable either to the plaintiff or to the third-party plaintiff for remedy over, what does that say? Contribution.
Right.
Now, contribution comes, and that's what this treatise I'm going to give you a copy of says. Contribution comes from contribute. It comes from the word tribulation. And I'm sure some of you are familiar with Revelations. Revelation says there will be great tribulation, doesn't it?
Yeah.
You're seeing Bible prophecy being fulfilled before your eyes. So what I'm going to do is bring great tribulation under contribution. Remember, contribution comes from the word tribulation, which is in the Scriptures.
That's right.
It means to pay with. So the reason I'm bringing this up, when you pay off somebody's claim, which is what you're doing, like all these forfeitures, and all of these, there are some lawyers that are aware of this, but because of their bar association, they're not going to do this.
That's why it's the people that have to do it.
That's why the people have to do it, and they pick the right person because I've already done this. I have the complaint already done. Mm-hmm. And I have a supplementary rule G. All we're doing is we're going to give them 30 days. The original claim says 15 days, but we're giving them, we haven't heard, the 15th will be up next Thursday, the 15th day. So we're going to give them another 15 days. We're going to give them a total of 30 days, and then we're going to sue them. We've already got a lien on them. We're going to foreclose on them. We're going to do to them what they're doing to you.
Right.
They're foreclosing on you, so we're going to foreclose on them.
And that's what we need to do.
That's what needs to be done to stop these people. And I know how to do it, and I'm going to do it. I'm not playing with these people anymore. So if you want to, how many of you know Connie? Connie is the one that's helping me. She's the one. If you want to do this, you need to email me, and I'll, we need a copy of your deed of trust and your note.
What if you're not able to get a note?
Well, you can get it. Almost everybody has. They give you a copy of this at closing.
No, they don't. Not always.
Well, tell them to ask the lender for a copy.
Some of the lenders are out of business. Some of the original lenders are out of business, and I know I never got a copy of my note. And it's 20 years old.
Well, the only other thing we could do is to, if you got the name, do you have the name of the lender?
Yeah, I've got the 424B5 prospectus too. And the
if you have the name of the lender, when the month and the year that the loan was given, and the amount of the loan.
Yep.
Have you got the deed of trust?
Yes.
So we need the deed of trust and the note, the promissory note.
Yeah. And for those of you that don't have a note or cannot get the note, you can take your information off your deed of trust. It will tell you the closing date, the amount, the company's name. So you'll have all the information on your deed of trust if you, like me, cannot get a copy of the note.
We're going to go after these people. And if they don't capitulate, we're going to do a forfeiture. We're running this thing, not them.
There were several people a couple of weeks ago, Gene, that emailed us to that wanted to be put on your in-rem complaint. So if you guys just want to send me an email, or I will develop the list for Gene.
Okay, but this is just a third-party complaint. Now, if you go, and I'm going to go down there and show you. This thing's not going. Okay, there it is. Okay, if you go down here to
after the complaint,
here's the rule we're going to use. I'm showing you this. Here's your supplementary admiralty rules right here. They're under the Federal Rules of Civil Procedure, which is all admiralty. All of these rules here, 1 through, 86? These are all admiralty maritime rules. Now here's the rule we're going to use. This rule covers a forfeiture action, MREN, arising from a federal statute. Well, what's the federal statute we're going to use? I'm actually doing them a favor. Why am I doing them a favor? Because I'm going to show you why I'm doing them a favor.
Does this apply to people in court too, or in lockup?
Yeah, it's all a tax liability. They're holding you for the taxes.
Okay. Jean's email is Michnowski-Tom, MICHNOWSKITOM @yahoo.com.
I'm going to give you another email. It's a Google email. And here's how you spell it. Jean. And the second word is keating. CEATING @gmail.com. That's where I want you to send it. This is what we're doing here, and I'm showing you this so you can see what we're doing. These are claims. This is a claim of the United States government, so we're doing it. What does that say?
Priority of government claims.
Okay, I want you to read that.
A claim of the United States government shall be paid first when a person indebted to the government is insolvent and the debtor without enough property to pay all debts makes a voluntary assignment of property. Property of the debtor, if absent, is attached, or an act of bankruptcy is committed, or the estate of a deceased debtor in the custody of the executor or administrator, if not enough to pay all debts of the debtor. This subsection does not apply under Title 11. A representative of a person or an estate, except a trustee acting under Title 11, paying any part of a debt of the person or estate before paying a claim of the government, is liable to the extent of the payment for unpaid claims of the government.
So what we're doing is we're going at, this is a priority claim, and we're doing it ex-real in the name of the United States. And if you are a private attorney general, you can do one of these. This is a priority claim because it involves taxes owed to the government under 3713. This is very powerful stuff. This is a priority claim. This is all a part of this making a payment. What they're doing is collecting taxes from you. But all of these, what they're doing is billing you for taxes when they send you a tax bill. Remember, a tax bill represents how much of your credit they're using. So now apply that to these mortgages. These mortgage companies are billing you for a mortgage. And the amount of the alleged mortgage represents the amount of your credit that they're using. So we're asking them for a reconveyance and a release of lien.
Or they face the penalties.
We're going to do a 1099-C on them, showing the amount that they owe us as forgiveness of indebtedness.
If everybody did that to their mortgage companies, there wouldn't be any mortgage companies.
If they want to play hardball, let's play hardball.
Right.
and I think that this is talked about, and they have a publication on this.
Investment income and expenses.
See, this talks about REMICs.
So even if you're in jail, it doesn't matter. It's still a REMIC. If you have a mortgage, it's still a REMIC.
It's a REMIC, so it's an in-rem proceeding. So what they're doing is they're doing a forgiveness of indebtedness. So this publication 550 talks about investment income. And what they're doing is what they do is they owe you investment income. And they're not reporting it as income. So what they're doing is a forfeiture of your property to pay their tax on the capital income they have. Now this goes into somewhere in here. I'm going to find it, and it talks about when they do a forgiveness of indebtedness. Let me see if I can find it this way. Which is what a 1099-C is. This is what the IRS does when they do a foreclosure. This is what they're doing. These people are foreclosing on you. I'll have to find it.
Okay, I'll put that down on the list up here, which is
when they do a forgiveness of indebtedness, it becomes income to the person that's forgiven on. Now, Maria knows, is it Gary Wayne?
Kenny Wayne.
Kenny Wayne. Kenny Wayne, they arrested him on a traffic violation. And they put it, what, they hold him for 3 or 4 days?
No, I think it was in there more like about 7 or 8 days.
7 or 8 days?
Yeah.
And they, when he got out, he filed a claim, a written claim. He gave him 30 days to answer it. They didn't answer it, then what did he give him, 90 days?
He gave him 60 more days till it got to the 91st day, which made it an accounts receivable. And then
which made it
forgiveness.
Then he did the forgiveness. If you want to know if this works,
He
tell
shut
him what
the
happened.
Down.
Tell him what they did.
Well,
They went in there and and confiscated they have a county board of directors, and they went in there and got the commissioners' houses and bank accounts and shut them down.
Yeah. And then when they got done with the commissioners, they went after the city. And the city was shut down. Took every penny the city had. And they didn't have money for operating costs. They had to borrow money for operating costs. My understanding that there's not too many policemen on the road that are writing tickets on the road anymore. It just got too expensive for them to even try it. And so the communities are beginning to learn that people have the last word.
This is the now the IRS went in there and shut this whole town down. Nobody. The IRS is like a pit bull with AIDS.
Why are you guys talking about a 1099-C to the United States for the national debt? Man, come on. Start studying a little bit, guys. Jane has said about 10 times it will be an NREM complaint. Why are you writing these questions?
See how this talks about contributions? Like here it talks about contributions to capital. Now this is 55. I want page 56.
We have a listener here that wants to know if your NREM is going to be in conflict with the early one started by Mitchell Stein.
Yeah, he wants to get in on it. We're going to bring him in. Okay, this talks about, here it talks about bad debt, which is a, oh, listen to this. What does that say? Can you read that?
Where?
If I blow it up?
Basis and bad
Rights
debt.
against borrow.
Basis and bad debt required. Right? Is that what you want? Where do you want me to read?
Yeah.
To deduct a bad debt, you must have a basis in it. That is, you must have already included the amount in your income or loaned out your cash. For example, you cannot claim a bad debt deduction for court-ordered child support not paid to you by your former spouse. If you are a cash method taxpayer, most individuals are, you generally cannot take a bad debt deduction for unpaid salaries, wages, rents, fees, interest, dividends, and similar items.
Well, isn't this a bad debt?
It's a bad debt because they're not paying the taxes.
Yeah.
They're the ones holding the contraband. They're the ones that have done illegal securitization by divesting the note from the deed. They're the ones that are trying to collect on an unsecured debt, which is not allowed. So
Okay, read the line where it says rights against the borrower. Read that.
Rights against the borrower. When you make payment on a loan you guaranteed, you may have the right to take the place of the lender. the right of subrogation. The debt is then owed to you. If you have this right or some other right to demand payment from the borrower, you cannot take a bad debt deduction until these rights become totally worthless.
Well, when do they become totally worthless?
When they foreclose on you.
Yeah. There's your bad debt. You can use this is on page 56. You're bailing out all these people and not getting reimbursed.
And they have to pay you back everything you paid on that supposed in the pie in the sky loan that you never got.
Yep.
Plus
and
all
you
the
have
damages they owe you.
Yeah, you have to do this under taxes because it's an admiralty in rem proceeding.
You can give them some conditional acceptances under discovery with a ledgering and set up the mortgage company so that you get a claim on the 91st day, and then you can forgive that claim and essentially start putting these mortgage companies out of business.
Yeah, that's what we're doing. What you're doing is loaning money to these. So you have a bad debt. What does that say? It says loan or gift. Read that.
For a bad debt, you must show there was an intention at the time of the transaction to make a loan and not a gift. If you lend money to a relative or friend with the understanding it may not be repaid, it is considered a gift and not a loan. You cannot take a bad debt deduction for a gift. There cannot be a bad debt unless there is a true creditor-debtor relationship between you and the person or organization that owes you the money.
So you got a deduction. You got a bad debt deduction.
When they start to foreclose on you.
Huh?
When they start to foreclose on you.
Yeah, what we're doing is we're foreclosing on them.
Right.
What's good for the goose is good for the gander.
Yeah.
So we're going to do it. We're going to do this. I'm not playing with these people. I'm tired of this crap. They've been getting away with murder. And nobody's doing anything. Everybody's just filing.
A lot of people's lives are ruined and destroyed over all this.
But you need to do this as an in rem proceeding under admiralty. And nobody's doing that.
Well, when you draw up the sort of class action in rem suit, everybody that sends me their name gets it put on a list. The list is growing. So now let's get back to this electronic filing. When you do an electronic filing on the 1040 ES, do you attach, you said you attach your private money order to it?
You attach your private money order and your taxpayer identification number, and you get a PIN number.
Or if you have a CPA that's versed in all this, the CPA can do it for you?
Yes.
Okay.
And you can, what you do is you set up an account. It says here, you call this number, 1-800-982-3526. Enter your taxpayer ID number. If you're a business, you use the EIN number, which is your employer identification number. If you're an individual, you use your Social Security number. and you'll receive a PIN number you received in the mail. And there's the last 8 digits of your enrollment number. And if you want, here's the numbers you call. 1-800-555-4477 is for businesses. You have to have an EIN number. And if you're doing it as an individual, you call 1-800-316-6541 for individuals.
And that's for the enrollment number.
That's for the enrollment number. They'll give you a PIN number. Then you go to WW. This is how you, and once you get your account set up, this is how you make a payment. It says you log in with your EIN or your Social Security number and your PIN number. Remember, you got to call them and get a PIN number.
Okay.
And you call this number here, 1-800-316-6541 for individuals. You give them your Social Security number, and they'll give you a PIN number.
Okay.
And then you use your PIN number. Then it says, and it tells you how to do this. It says, select the tax form, payment type, period, and amount.
So how do you determine the amount?
Well, the amount is the amount of they're billing you for.
Okay, the amount of the money order.
Yeah. The amount of the bill is the amount of, you've been conditioned to believe that you're a debtor. You don't think like I do. I act like a creditor, not a debtor. That's why I do these conditional acceptances. When you do an acceptance for value, you're admitting that you're a debtor. You contract with them, then you become liable for the debt. If that's what you want to do, but you have to understand what you're doing, you become liable for the debt.
So how is the money order different than the A for B?
Well, the money order is you're making this is what you're, and a judge told them. And I've been trying to tell people this for you don't use the word accepted, you use the word accept. A judge told this guy in the courtroom, he said, you guys are doing this all wrong. People are not doing, you don't do accepted for value, you do accept for value. You don't use the past tense.
Because everything has to be in now tense.
Yeah, not in the past tense.
Okay. That's like having the money order say paid paid to the order of versus paid to the order of.
That makes it a negotiable instrument when you put paid to the order of.
Right, and if you put paid, P-A-I-D, in the past tense, that's what disqualifies it.
We did this on a car loan. They're trying to repossess the vehicle. We did pay to the order of. They haven't tried to repossess the vehicle, but they haven't credited the money yet. So we're going to do a forgiveness of indebtedness if they don't do it. We're going to convert it to a receivables. In fact, just to show you how, well, I'm not changing the subject here, but I'm just showing you, since we're talking about receivables, here's how they do this. Now this is a car loan, and this is an S3 registration. This is an S3 registration statement. Can you see that?
Yes.
Okay, what they do is they take your installment Now this is something. This is a case I did for this woman. We're going to get her car. They haven't got her car. She refuses to give it back. But we're going to get the car back, or we're going to get the money back. Notice it says Citizens Auto Receivables. Now here's the company that's coming after them. Citizens Automobile Finance, Inc. And I'm showing you to show you how they do I'm going to show you here's the flow chart. I did a letter for this gal, and I took the flow chart.
We went over that here a few weeks ago.
Yeah, see, this says Citizens Automobile Finance, Inc. It's the sponsor, originator, and servicer. Now, this is the same thing as this is a car loan, but this is the same way they do a mortgage. Notice it says receivables.
Right.
So what they did is they took your receivables and they put them into this. They sold them under a purchase agreement to Citizens Auto Receivables, LLC, which is the depositor. This is a Delaware corporation. Remember, the receivables is the retail. If you want to see what one looks like, I'll show it to you. Let me go through this first, and I'll show you what it looks like. Citizens Auto Receivables, LLC, is the depositor. They took your retail installment contract and security agreement and used it as the assets to pay for these notes and certificated securities, which are issued by this Citizens Auto Loan Trust. This is the issuing entity. See, it says issuing entity. Now here's your underwriters and here's your investors. So they sold the certificated securities and notes to investors. And they used your money to do this, to buy them from here.
Yes.
Now tell me that isn't an investment contract.
Of course it is.
Well, you're entitled to reimbursement and restitution. What they did is they did a merger. They merged your retail installment contract with this, with the LLC.
They kept all the equity in it.
Yeah, here's what, if you want to see what it looks like, here's the actual, and I'm showing you this so you'll know. This is the actual, this is the retail installment contract. See, it says retail installment contract and security agreement.
Right.
And it's for $41,909.75, and they're making 84 payments.
Right. So if anybody has one of these, even from years ago, that's what you take and put a money order on.
Yeah, you can do a money order on this, but what we're doing is we're not giving them anything. We're asking them for money.
Right.
What they did is they took your retail installment contract and did a material alteration under 3-407, which is a merger. Okay, when they merged this with the Auto Receivables LLC, it discharged this. See, it says promise to pay and payment terms. This is a promissory note, but they didn't treat this as a liability instrument.
No.
Under 3-104E, they treated it as a draft.
Correct.
Because they used it to buy the assets.
Right. Can you include more than one private money order on a 1040 ES?
I believe you can if you do it, if it's in the same quarter. It has to be within the quarter. They file these quarterly, just like they do
Right.
SEC forms.
Right.
So they're all these SEC forms are. They do these.
Is it harder to get rid of a loan through a credit union?
No.
Now, what happens if you paid a car off at closing? You still have your paperwork. You still can reclaim it.
They're doing this. That's what they're doing. They're paying. The loan was paid in full at close. There never was a loan.
Right, but somebody...
Where did they loan these people? Where did they ever give? They gave them the car, but where did they loan them any money?
Right, but this person is saying that they didn't have a loan application. They just had a purchase agreement, and they purchased the automobile outright. So they can go in and turn that over.
What does this say? I want you to read this. Right here. Can you read that?
The issuing entity will own a pool of receivables consisting of motor vehicle retail installment sales contracts and motor vehicle installment loans secured by new and used automobiles and light-duty trucks. The pool will consist of the receivables that the something simultaneously transfer to the issuing entity on the closing date. The receivables will include payments on the receivables that are made after the cutoff date.
So what they did is they converted your receivables, which is, and this is what I mean by you have to understand accounting. Receivables are what's owed to the bank, and payables are what they owe you. But they treated this as a payable, not as a receivable. And because you didn't claim it, they treated it as abandoned property. So they used your payables to pay for this pool of receivables. And they sold it to the issuing entity, which is this auto loan trust.
So what are the payables are used to pay what? To pay the receivable? No.
To pay the auto loan trust for the certificated securities and notes that they sold to the investors. They used your money. They took a debt instrument and converted it to an asset. I'm going to show you in here where it says that. I can find the
Jack, it is seating, C-E-A-T-I-N-G. You're not listening. Some students are asking if there's more expenses after they pay you the $3,000 for their particular program. No.
No. They're actually using your money, which was a debt instrument. Anytime what corporations do is they spend debt.
Right. They go buy more new cars and more inventory.
Yeah, they're using your money to do it. Okay, read this. What does that say right there?
Read what?
Issuing entity. I want you to read this.
Issuing entity trust. Citizens on the Loan Trust 20 whatever. A Delaware statutory trust will be the issuing entity of the notes. The principal asserts assets of the issuing entity will be a pool of receivables, which are motor vehicle retail installment sales contracts and or installment loans that were secured by new and used automobiles and light-duty trucks.
Notice they're calling a debt instrument. Aren't they alleging that I'm trying to make you understand what's going on here. They're telling you that the installment contract, which you allegedly borrowed money from,
is an asset.
And they're using these pooled assets to pay for these certificated securities and notes that they're selling to investors. And they're using your retail installment contract as the assets to buy these. Duh.
Yep.
Is that what that says?
Yep.
But see, nobody ever reads any of these things.
Right. The form to investigate is the forms that Jane's putting together with the complaint, the 3949, the 8300, the 1099-C, the ag lien.
Now, isn't that the FASB number 95, Statement of Cash Flows? Isn't that what that says? It's a payment to the depository and a receipt to the bank, and a receipt to the depository and a payment to the bank. You made a payment when you signed the installment retail sales contract, which they treated as an asset. You made a payment to them.
Until you go in and forgive the debt to them and turn it right around back on them.
You funded the entire operation.
Okay. So if you guys have some more questions on the electronic filing, because that's what tonight's show is, make sure that you understand there's date specific for specific quarters. Whichever quarter you start with for your older accounts, just depends on which quarter you're going to start with this.
But you got to use the right form on the 1040-ES. You got to use the right form to make. You can make the payments using your 1040-ES form.
How do you electronically send both sides of the paper on a money order, unless you make separate copies of the back of the page?
Actually, you could see, these banks are acting as backup withholding agents, And what you could essentially do is do a money order to the bank, and then they treat it as a deposit, see?
Mm-hmm. But most of the banks are not willing to treat it as a deposit. That's the problem.
Well, you can...
they go to every length they can to let you think you've done something wrong. They send it back to you.
That's because you're not doing it right.
Okay, so what are some of the pitfalls that some people are doing when they don't do this? When they do, how do they do it wrong?
Well, see, like this, it talks about the EFT, which is your electronic funds transfer acknowledgement number.
Okay.
I think that you can do an ACH, which is automated clearinghouse.
We have to cover that under another show, Gene. People are still a little confused on this 1040
Well, what are you confused about? It's you use the 1040 ES as a payment voucher.
Correct.
Instead of using the 1040V.
Correct. But are there restrictions on what you can use that voucher on? Some information has been coming down that you can't do it on, if you try to send in your money orders on utilities, they'll just shut your utilities off. You can do electronic transfers on mortgages and car loans and, stuff like that you can pay. But most of the time when you send these servicing banks these money orders, they return them to you and try to make you think you did something wrong.
Well, they're not all doing that.
What are some of the pitfalls that some people might get into with this private money order and 1040 ES?
This is...
to make it not go through. I turned in a private money order 3 weeks ago on this suspended license of mine, and so far as I can tell now, the license has been unsuspended. So it's not suspended anymore when I looked it up on the Department of Licensing's website. But we send in a private money order for my son's child support. We have not heard on that yet. There's no indication. They're still garnishing his paycheck. So,
what you should do is do a 1099-C, debt cancellation.
Well, we're planning on doing that. But there's been information that some of the money orders take up to 90 to 120 days to process. And the IRS is so backed up now that if you did it hard copy, which is what we did, can we go in and do the 1040 ES electronic payment because it was made hard copy?
Yes, I think you can, yeah.
Okay. And then that way it would go automatically.
Then you don't have that big waiting period. That's what I think the IRS is backed up. People are doing these accepted for values, and they got them on pallets and you got all this paperwork, and they don't have the manpower to process them.
To process them. A lot of us did a lot of A for Vs, but the money order is a much better way to go. And the thing is that if you pay a bill with that...
Let me call you back.
you can, if you pay the bill and circumstances change, and that recipient doesn't have the authority to receive that payment, you can turn around and do the forgiveness of that debt anytime you want and give that person the tax liability. Am I correct on that?
Yes.
Okay.
You're paying all their taxes. That's why the American people, what does it say? My people perish for lack of knowledge. Because they have rejected knowledge, I have rejected them. You're paying all these people's taxes. The forfeiture. It's not a foreclosure, it's a forfeiture. What did they forfeit? They forfeited your property to pay their tax.
Correct.
Aren't you paying for that?
Right. That's right.
Well, you should file a 1099-C. Debt cancellation. Turn it into income.
Right. Jack, you're not clear in your question. Ask it again. Okay.
What's his question?
He wants you to expound on the use of the 1099-C. The 1099-C is simply saying that you're going to forgive a debt. In other words, if you've used a money order or you've used and paid off a car, and they didn't give you that credit and return the source of funds back, the funds back to the source of the funds, you can forgive that debt because that debt is owed to you. And when you do that, the tax liability will go on the other party. And that's what we're doing with the conditional acceptances and with the counterclaims and discovery requests, with ledgering on them. If they don't answer, then we have a claim against them. So when they don't take care of the situation, you can take and forgive all of the claim, part of the claim, all of the parties, part of the parties, and they will get the tax liability of that claim against them that you have against them.
Can you see my screen?
Let me finish here, Gene. There's no way to get a sample of the claim from the other gentleman. Period. You must understand the theory behind it. He simply said, you put me in jail wrongfully. I'm charging you $10 million because of for the days that you kept me wrongfully retained me. You have 30 days to answer my claim. He filed that claim in the public record, and he gave them an additional 61 days, because in banking, you have a 91-day period of time that must expire before you have an accounts receivable. On the 91st day, Kenny simply forgave some of the people he had a claim against, and those people got the tax liability of that claim, which was $10 million each of them. And when IRS went in and cleaned the clock of those commissioners for a $10 million tax liability, they didn't have anything left. Then, being employees of the city, IRS cleaned the clock of the city, making it impossible for that city to operate because IRS cleaned out all their bank accounts. What do you mean here? Will the electronic filing payments prevent the filing of the payment of a debt? That doesn't even make any sense. Do you always pay the U.S. Treasury? Why wouldn't you always pay the U.S. Treasury? Of course you would. And you charge the memory, the sum said, to the person that's making a claim against you. Then they have that claim as a tax liability that they got to pay out of their pocket and their wages. Real good teaching lesson.
That's how you assess the tax. What you're doing is you're not paying the tax, you're assessing it. And you do that on the 1040 ES. That's a payment voucher.
Right.
You pay the tax, then the IRS bills them for it.
Okay, can you use Title 31, Section 742 to be effective by making the corporation, United States, liable for all taxes under the code? Is there a new section? I don't know why people can understand I'm not available. I'm not available. I'm sorry, guys, for that. So there is a new section 3124.
Well, you're talking about 742 is debt instruments of the United States are not taxable.
They're all taxable when you use a Federal Reserve note to pay anything, because that is a debt to the United States corporation. They owe you. How do we do this process properly? Go listen to the webinars. They're all in the webinars. Here's one. A court case was paid by a money order. The judge refused to discharge the debt. What is to be done? You file a 1099-C and give him the lovely tax liability.
Yeah, you make it a receivables.
Make it a receivable.
Remember, when it becomes a receivable, what happens is they take the receivable and they can use it to pay the tax. They're supposed to pay these taxes, not you.
Correct. They're not your taxes, they're their taxes. How do you do a claim again? Listen to the webinar when you get it, Monday or Tuesday or Wednesday next week. Is the Department of the Treasury, the IRS, and the U.S. Treasury is not the same? That doesn't make any sense.
The U.S. Treasury.
Department of the Treasury versus U.S. Treasury.
The Department of Treasury is the U.S. Treasury.
Okay. The U.S. Treasury is not always necessary for negotiable instruments. That doesn't make any sense either. Which webinars do you get on this one? You should be getting them all to build your foundation. You can't build a house without a foundation. And if you try to do it, you're going to get into a get into jail card real easy.
The real U.S. Treasury is down in Puerto Rico. Carlos Mendez Torres is the Secretary of the Treasury of Puerto Rico. It was moved down there in 1921. Timothy Franz Gussner is the Governor of the International Monetary Fund. So you're dealing with the International Monetary Fund, not the Department of Treasury. Okay? Does everybody understand that?
We've got just a few minutes left for some additional questions. 10 minutes to go, Jean. Is there anything we need to go over slower?
Here, you need to go to get the instruction booklet. Here is the instruction booklet on the 1099-C and the 1099-A. It says, when is a debt canceled?
A debt is deemed canceled on the date an identifiable event occurs, or, if earlier, the date of the actual discharge if you choose to file form. Wait a minute, I got to close this thing because it's right in the way of my reading. Let me see. If you choose to file Form 1099-C in the year of cancellation, an identifying event is a discharge in bankruptcy under Title 11, the U.S. Code, a cancellation or extinguishment making the debt unenforceable in a receivership, foreclosure, or similar federal or state court proceeding. A cancellation or extinguishment when the statute of limitations for collecting debt expires, or when the statutory period for filing a claim or beginning a deficiency judgment proceeding expires. Expiration of the statute of limitations is an identifiable event only when a debtor's affirmative statute of limitations defense is upheld in a final judgment or decision of a court and the appeal period has expired. A cancellation or extinguishment when the creditor elects foreclosure remedies that by law end or bar the creditor's right to collect the debt. This event applies to a mortgage lender or holder who is barred by local law by pursuing debt collection after a power of sale in the mortgage or deed of trust is exercised. A cancellation or extinguishment due to a probate or similar proceeding.
Okay, if you read this instruction, I'm going to go up here to the top and show you. If you go up here to the top.
But all of those do not apply to fraud, Gene. There can't be what do you call it? When there's fraud involved, there cannot be a statute of limitations. So essentially, everything is covered.
It says here the court must file a 1099.
So why cannot people file the 1099-C?
Well, what you should do is make the court file it. The court is required to file these.
They are required, but that doesn't mean they do it. Or that
well, make them do it, or you're going to do it, or you're going to file one on them.
Well, that's the issue. If they do it behind your back, and you don't know about it, and you give them a claim and give them 91 days to prove that they've made the claim or that they've done it, and they don't do it, then you can file the 1099-C on them for the amount of that claim.
Yes.
And that means the amount of your car loan, the amount of your mortgage, the amount of a judgment that's taken against you.
But it says in here, now they don't have the, I believe this is the new, who must file? I'm sure it says, let's see.
Well, it says down there on 5C, a court. You just bumped it off.
Did I go by it?
5C. You just bumped it off. I think it was up above. You got to go up. It said who must file.
Yeah, here it is. It says a court or court administrator.
Right.
So if you need to tell the judge, tell him I'm forgiving, I'm doing a forgiveness of indebtedness, and I'm instructing you to file a 1099-C. That's what I do in these letters, and I've been gotten rid of every one. They're supposed to do that because it becomes income to them then. Once they file that, then they're liable for the income. Because it's income, whoever it's forgiven to, you got to name them as the one that's being forgiven.
So when you
tell them you're going to name them as the one that's forgiven.
When you put a letter of forgiveness in a court case, they have to do that 1099-C against whomever you're forgiving. And if the court doesn't do it, then you have the right to turn around and do a 1099-C on that judge. So, let's see if there's a couple more questions. We're out of time. It's at 8 o'clock here, Gene. I'm going to look at a couple more questions here. The get into jail card, folks, is trying not to understand the entire theory and foundation of these processes before you do it. Now, if we can file the 1040-ESs with our regional offices, can't we? Or,
yes.
Or you can do the electronic through a CPA that's authorized, or you go in and get your own account.
Yes.
Do we still have to do an 8281 with a 1099-C?
No, you do a 8281 on an OID.
Yes. For the study group, send me an email. How do I find the B5 prospectus for a township? I don't know that there was a B5 prospectus for a township ever.
Ask them for the deposit agreement.
There's 3 agreements.
Call the state treasurer. The state treasurer is the one that.
The state treasurer.
They're the ones that
won't give you any information, Gene. I tried that here. They put me back to the city, to the county treasurer. County treasurer said they didn't know anything about any of it. I think we needed to go to the court administrator.
Well, go to the court administrator, see what they say. I'm telling you what the practice says. You need to go read Circular 7 and Circular 16.
Okay.
It tells you how they do these.
Is there a sample of forgiveness?
What I'm going to have to do is go in there and pull this stuff so we can I've got the Circular 7. You can download that right off the internet.
Did you ever find Circular 16 yet? We've had several people looking for it too.
Yeah, I haven't found it yet, no.
If you have a court judgment against you, you just don't go running in and do a 1099-C. You got to set up a claim, and in order to get it seasoned before you can do a 1099-C. Don't get the cart in front of the horse. How much does Gene charge for a court case over a credit card issue?
You got a credit card?
One of the students does. You can take and pay that credit card off with a money order and be done with it. That's the end of the questions, Gene, and we're at the end of the time. I'd like to say thank you to everybody that attended. We sure appreciate you being on the line and learning all this stuff. We're all learning together. And we want to make sure that I want to bring Isaiah 54:17. Any false statements made about you, to you, or in regards to you, the universe says will not stand up and will come back to the other person tenfold. I don't have the exact verbiage on that, but I'll pull it out and read it next week. Any closing thoughts, Gene?
I love you, dear memories. I forgive you, my dear memories. I'm grateful for you, my dear memories. I trust you, my dear memories. I thank you, my dear memories, and I'm sorry for you, my dear memories. I love you all, and we'll see you next week.
Thank you, and good night.